Good afternoon, this is Sean Golding with Golding & Golding, here to provide a 2025 update for expats living overseas. What they have to file, how they have to file, what forms they have to file, and if they can avoid any sort of tax and reporting. So by U.S. expats, we're talking about people who are still considered U.S. persons for tax purposes, so not people who are formally expatriated. Typically, it's going to be three main categories: U.S. citizens, lawful permanent residents, foreign nationals who meet the substantial presence test. So what happens is when a person is considered a U.S. person for tax purposes, they're taxed on their worldwide income and they're required to disclose their global assets. So even if you live overseas, all of your money is overseas, you're earning income only from foreign sources, so it's all foreign sourced income, all of your accounts are overseas and assets, you still are required to report this information to the U.S. government on your tax return and the various international reporting forms such as the FBAR, Form 8938, Form 3520, 8621, etc. So one important issue that has come up recently is whether taxpayers have to file the FBAR if they live overseas. So it's important to note that the IRS takes the position that you're required to file the FBAR, okay? If you're a U.S. person and you're living overseas, you're supposed to file the FBAR. If you're in a non-treaty country, there's not much you can do. There was a recent case, ROS Day, and in that situation, the taxpayer was living in a treaty country and made an 8833 election to be treated as a non-resident alien. So the U.S. government takes the position that you're still required to file all of the reporting forms. In this particular situation with the FBAR, the courts actually came down on the side of the taxpayer and said he shouldn't be subject to non-willful FBAR penalties because he shouldn't have had to file them in the first place because he had made a treaty election. Chances are the IRS is going to challenge it when it comes up, but that is the recent case, and so taxpayers who are making treaty elections can consider whether they want to file the FBAR or not. So if you're earning income overseas, let's start with foreign tax credits because that's a big one. If you're living overseas, even if you're not, but this is geared toward expats, if you're overseas, you're earning foreign income and you paid foreign tax, you may be able to file a Form 1116 if you're an individual and claim foreign tax credits. What is important to note is you report the gross income, not the net income. So let's say you made $100,000 and you paid $20,000 in foreign taxes. You would report the $100,000 and then you would report the $20,000 for tax credits. Sometimes people would just report $80,000, but what happens is then you're going to get taxed in the U.S. on that $80,000, and the tax credits don't really apply because it's more of a deduction. So remember, you want to report the gross income and then you want to claim the foreign tax credits. Now, depending on what country you're in, your personal income, your passive income may not be taxable. It may be exempt in that country. Unfortunately, the U.S. takes the position that it's still taxable in the U.S. So if you're in a country that doesn't tax personal income, you're in a country in which, dividends, capital gain, interest is not taxable. The baseline position from the U.S. government is that you are required to report this information on your U.S. return unless there's an exception, exclusion, limitation, something in the treaty, regulation, etc., etc. It's still going to be reportable and taxable. Now, if you're living overseas and you have a foreign trust or a foreign entity, those are reportable in the U.S. as well, and that reporting can get a lot more complicated. If you have a foreign trust, you're typically going to file a Form 3520, 3520A as an atom. If you have foreign entity, you're probably going to have to file a Form 5471 or an 8865 if it's a partnership. You may be able to disregard the entity, but not always. The IRS has a list of what they call per se corporations, which means if you have, even if you're a single member, if you have this type of foreign corporation, you can't disregard it for U.S. tax purposes, such as a Canadian corporation or the Sociedad Anónima, which is very, very common. Even if they're being used for state tax purposes, even if they're being used, this is like a holding company to hold your foreign investments because you don't live in that country, you're not a citizen of that country, rather, you're still required to report this information on your tax return in the various reporting forms. Now, when taxpayers are considering renouncing, that's a whole different issue So when you see the term expat online versus expatriation, it's not the same, right? When someone's referring to the expat, they're referring to a U.S. person who still has to file. When people are referring to expatriation, they're referring to someone who has formally given up their U.S. person status. The reason why this is important when you're making treaty elections. So sometimes after being, let's say, a permanent resident for several years and living overseas as an expat, someone decides, oh, you know what, I can make a treaty election. I can be treated as a non-resident alien. But there is a tripwire, which is if you've had the green card for more than 8 of the past 15 years and you never made that treaty election before, then that, and you're already considered a long-term resident, well, then that might be your expatriating act, which is very important because depending on what your net worth is, your net income average tax liability, and if you're tax compliant, will impact whether you're a covered expatriate, and if you're covered, if you're subject to exit tax. If you're out of compliance and you're looking to get into compliance, there's various programs that you can go to. If you're willful, you do the voluntary disclosure program. Most people are non-willful, so there's lots of different programs available. Streamlined domestic offshore procedures, streamlined foreign offshore procedures, delinquency procedures, or possibly a reasonable cost submission. If you're an expat and you can qualify for streamlined foreign, that's typically going to be the best program because there's a certification program, so you're signing it and the IRS accepts it on the form 14653, but there's no penalties. So between no offshore penalties, qualifying for the foreign earned income exclusion, and foreign tax credits, you may actually get back into compliance without any issues. So be wary of lawyers and accountants who are trying to scare you into believing it's way worse than it is. Usually it is not. The IRS has many programs to help taxpayers get into compliance. We have a ton of free information available on our main website and our sub-website. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.